Hey there. Thanks for watching my videos. This is Drew. Following up on my arrest video from August 30th of 2022 and up till now. For those of you that don't watch my channel, I got arrested by a sheriff's deputy named Jason Bueno. He hotbox tortured me, and I was charged with trespassing and obstructing a government facility and just a bunch of BS. Ultimately, the charges were dismissed on December 20th, 2023, and then I started posting more videos of our incident together. Subsequently, Deputy Bueno has filed a restraining order summons against me, so he's trying to get a restraining order. Anyways, the other day I did post a little bit about this. I did about a 2-hour live. If you want to go back and look at that stuff, I'll tag both of those videos in the description here. But watching this video, Bueno's got some things to prove here. Today's not going to be the day for him to prove this. For those of you that watched the live stream and the other video where I did record in the courtroom, you probably know what the ending of this is going to be like. But the beginning, none of you have seen yet. So listen to Deputy Bueno. And he's got some things to prove here. He's got to prove that I physically did something, caused something to happen to him for the charges that he's trying to prove against me in order to get a restraining order. You know, some of those things are, let's look at that. He basically is saying that, pull my papers up here. He's basically saying that this is an application for protection order against stalking, harassment, sexual assault, or harm to minors. And he gives a whole little complaint about this. And basically what the law says is I have to have taken some physical act of doing something. I have to have stalked him, physically put him in jeopardy, caused him imminent harm, that type of thing. So that's what he's going after. And in his complaint, he lists an incident on January 18th of 2024. And he says he received a phone call from this phone number, 469 something or other. So not a phone number I've ever heard of. And some guy was talking to him. I guess he felt threatened by that. And then he says at 14:31 hours, he received a message from his former mother-in-law. So that was what, 14:18 to 14:31. So that's what, 10, 13 minutes. Am I guessing that right? Anyways. So a few minutes apart there, his ex-mother-in-law called him after he received this message from this unknown male. Then he says he discovered that Drew Rebar, me, I'd posted a YouTube video earlier in that day with the title, Cop Tortures Prisoner, First Amendment Hotbox Auditor. And then he goes into all this other stuff about how he feels afraid. And then he says that I've constantly published these videos since my arrest. Says they're fiery comments. He feels threatened by the situation because he had to go to his kid's school, evidently. I guess he got a voicemail at his work, and his work is the sheriff's office, so that would be a public place. And that was on January 19th. And yeah, so he doesn't say that I actually did anything other than published a video about him, and he doesn't like the video. So listen to this court interaction. Listen to what he says about, listen to what he says. Post your thoughts in the comments. Let me know what you think. Like the thing, share the thing. And if you're not a subscriber, subscribe, and I'll keep following up on how you deal with all of this. And also, just a little highlight of what's to come. There's something called SLAPP, S-L-A-P-P, and I'm going to be filing a motion with regards to that. So something for y'all to look up, something to warn Deputy Bueno. I'll be getting him a copy of the paperwork that I'm creating, and I'll see him Wednesday at 2 p.m. in court. think you've I've been in front of you before. Did you do small claims in Reno at all ever?
Yeah.
I think years ago I was in front of you for a small claims case. You look very familiar.
I was elected judge up there for 4 years.
Yeah, and when you did a good job, so I appreciate that. You went through everything and you were very, very thorough. Does it sound like you?
I don't know. Other people's perspectives.
That's what I saw.
Okay, good morning to each of you. This is 24 PO 000231C, Jason Bueno versus Drew Rebar or Rybar? Rebar. It's a application for an order for a protective order. The law allows judges to issue upon application ex parte a temporary. If the judge wishes more information, they can set it for a hearing and determine whether or not an order, temporary or permanent, either way, can issue. So the original reviewing judge set it for a hearing to see if one should issue. That was Judge Armstrong. My name is Derek Dreiling. I'm a senior judge, a retired judge that recently retired, that formerly worked in Reno Justice Court. Now I travel and assist courts when they have need, and Carson Justice Court had their Justice of the Peace and Department 2 assigned to District Court, appointed by the governor. So they're in need, and I've been filling in from time to time, and today is one of those days. There's several issues to address before we get started. There's essentially been two requests by Mr. Rebar. One is to continue this hearing to fully prepare, as he was given verbal notice according to his statement yesterday, I believe around 10 o'clock. The court received a declaration of non-service. It's filed yesterday at 4:41 p.m. from Kristen Marquez, I believe an agent of the sheriff's office, indicating that yesterday at 4:23 p.m. she spoke to Mr. Rebar over the phone. He stated he would be here for the 9:30 hearing this morning. We had numerous hearings. This is the last one we're taking. We're starting a little late. So there's a request, bottom line, to continue because of the late notice of this particular hearing alleged by Mr. Rebar. Seems to be documented by a phone call yesterday at 4:23 p.m. from Kristen Marquez. Then there's also a request for the use of media cameras in the courtroom. It's normally a request made by reporters. Supreme Court Rule 229 and the following rules talk about it. So they require 24 hours notice so that the parties can respond. The rule talks in terms of attorneys, because usually they're involved, but I'm substituting the term parties because each party is here representing themselves, and there are no attorneys. So the statute, the court rule, Supreme Court Rule 229, requires 24-hour notice. Mr. Rebar's request indicates essentially that he didn't have 24 hours to work with, so is asking the court to allow recording because the Supreme Court rules do allow for late requests by reporters. that the court can consider and grant or not grant. There's a presumption that it's open to being recorded by reporters. The proceedings are also recorded by the court, and upon request, the court's copies are made available to parties. So those are two of the issues, and then before Mr. Bueno came in, I was seated waiting. Mr. Rebar had just engaged in polite conversation, indicating that he believed I looked familiar. He had seen me. He thought at Reno Justice Court in a case in the past. I, in fact, was a Justice of the Peace elected in Reno. Again, as I indicated earlier, since retired. Sat over numerous civil cases of varying natures. I believe he indicated it was a small claims case. Thought that I was thorough and prepared. Those were the only comments that were made. I've had, apparently, I don't recall, but because of the volume of cases, some contact with Mr. Rebar in the past at a case. He was satisfied with, it appears, with my performance for whatever reason. I don't recall Mr. Rebar or the case or anything about it. Again, due to the volume of the cases that we covered. So, Mr. Bueno, are you comfortable with me deciding matters in this case, at a minimum, these preliminary matters, knowing that Mr. Rebar has some limited familiarity with me?
Yes, sir, I am.
Okay. So then the next requests are the media request and allowing cameras in the courtroom. The purpose of that 24-hour rule is so that both parties could be prepared for the potential for it being there. And the statutes, or that court rule, I should say, demands that if I'm considering one of these requests, I have to consider, this is under 230, the impact of the coverage on the right to any party to a fair trial, the impact of coverage on the right of privacy of any party or witness, so the impact of the coverage upon the safety and well-being of any party, witness, or juror, and the likelihood that the coverage would distract the participants or would detract from the dignity of the proceedings, the adequacy of the facilities, any other factor affecting the fair administration of justice. So Mr. Rebar's made the request for the ability to have electronic coverage.
Do I get a chance to respond to that, sir?
Yeah, so hang on a second. The rule talks about news reporters, and that's the normal context this comes up in. And news reporter in 229 is defined as any person who gathers, prepares, collects, photographs, records, writes, edits, reports, or publishes news or information that concerns local, national, or international events or other matters of public interest for dissemination to the public. So I guess as a preliminary matter, Mr. Rebar, are you a reporter?
I am. I publish videos of government interactions. I have close to 100 videos published. The videos that have Deputy Bueno in them have received over 100,000 views. There is public interest in this case. Just before coming in here, I was outside doing a YouTube live video. There were 250 people watching. So there is public interest in this case. The information is disseminated to the public for them to judge and what their government is doing so that they can make better decisions about their votes in the future.
You've used Mr. Bueno's application as an example. Is your reporting limited to this case?
No. I started with a brief history. I started with the Nevada DMV, when they ordered the seizure of my documents without any reasonable suspicion and took my papers. And the Nevada DMV had created regulations as defined under NRS 233B-038 without any due process of the Administrative Procedures Act. And they started enforcing those laws under the color of law with guns and badges without ever having done any public meetings, without ever having gathered any information from the stakeholders and the businesses as required under 233B to implement a new regulation. And they did that for 2 years. And then when I questioned DMV Director Julie Butler,
So hang on a sec.
I've published a lot of different things, whether it's Deputy Bueno, Highway Patrol Troopers, DMV Director, the Chief of DMV Breaking the Law, government actors. He's not the only government actor that I'm publishing information about. I'll publish information about any government actor.
Okay. Thank you. So, Mr. Bueno, I do note the, I guess, irony somewhat, might not be the best term, the request to record when the underlying issue in part might be the recording and dissemination that are in the allegations. So it's not lost on me, but as far as responding to his request to have it recorded, what are your thoughts?
Mr. Rebar is not a journalist. The contents of the videos that he's presenting constitute a Category C felony of aggravated stalking and harassment against myself. There's a criminal case that's being filed on that matter this week. He heavily edits videos in his favor, and he makes money off of those videos on the internet to curry social favor and status as well as financial. I believe that another reason for him to try to introduce cameras is so that he can edit and sway more public opinion, which in turn is damaging myself and my family.
In a second, I was making a note.
Additionally, Your
Hang on
Honor,
a second. I had 2 points I wanted to write down. Challenging his status as a reporter, the editing, one of your other main points, if you could please restate it.
he's monetizing these videos, and he's mixing them around in order to produce libel, which is not covered under the First Amendment, as you're well aware.
Okay.
And publishing that on public forum.
Okay, so what was the point that you were then gonna get to?
Sorry?
What was the point you were gonna get to before I asked that question? You had something else you were starting to say?
Just the fact that he's using the journalism tact in order to commit gross misdemeanor and Category C felonies against myself. My thought on him having the camera in the courtroom would be to further his stalking and harassment of myself and my family.
And knowing that this is being recorded by the court already, and that he could ask for a copy of that, how does that impact your analysis, if at all?
My concern would be his heavy editing that he's known for, editing all content of either sheriff's office recorded videos or others to sway and basically whip up attention to his case, which he monetizes.
And if he did get a copy of the courts digitally, he could still edit, I assume?
I'm not sure procedurally how that works. Obviously, my attorneys would be aware of him editing those and publishing those. So I'm not sure exactly how him receiving that would be a conflict, in my opinion. Obviously, it's public record. But he has a history very well documented of what he's doing with the content of his videos now, as well as public record videos that he's obtained from the sheriff's office.
If he were allowed to record, I'm looking at the statutory factors, or the rule factors. impact on the right of a party to a fair trial, right of privacy of any party or witness, impact upon safety and well-being of any witness or juror, or the likelihood that the coverage would distract the participants or detract from the dignity of the proceedings. Any comment on those? I know I listed a lot.
I mean, specifically the stalking, NRS 200-575, and then obviously subsection 1, which outlines without lawful authority, willfully and maliciously engages in a course of conduct.
Right, but hang on. We're just talking about this particular hearing, not whether there was stalking, not the underlying allegations. So for the purposes of this hearing, let me just slow down a little. Do you think that this hearing would inhibit either party's ability to get a fair trial? Would it inhibit you some way or me some way? Obviously he wants it, so I don't assume it wouldn't inhibit him.
I believe his intended use is to sway as much opinion as possible to curry his favor. I believe that he would post those videos, which would in turn create more threats that I'm receiving daily. I believe that's what his intention is.
What about the impact of, it says coverage upon the right of privacy or any party or witness, any privacy concerns?
I do. Privacy is obviously a concern as it's been violated as a result of his actions. And I do apologize that we're double hearing aids.
Okay, I'll speak up. I tend to speak quietly. Is that better?
I should have said that before. Yes, sir.
Okay, I'll speak up. Any comments upon if he's simply allowed to record the impact upon the safety and well-being of any party or witness, you or any witness?
Yes, sir.
What's your thoughts on safety if he's recording you?
The safety issues that I would be concerned about, which began the situation, is the doxing, where he's publicly producing information related to me. My family members have been contacted. Locations of my children's schools have been revealed, all instituting a threat that's been initiated by Mr. Rebar's unlawful actions. So again, the privacy would be of concern to release more information subject to this case, I believe would damage and create more of a safety risk for my family as well.
Part D, likelihood that any coverage, him recording it, would distract participants, you, or detract from the dignity of these proceedings.
I believe it would.
Why?
I'm sorry?
Why? I mean, how would it be distracting if the camera's sitting there recording?
Because the source of what he's doing with that information and how he is twisting all facets of this case that have been proven through documentation and investigation and through the sheriff's office and the DA's office, he is knowingly, falsely making statements online using these recordings and proceedings and anything else that he makes, which is causing the threats towards myself and family. And I believe that having his camera in here is another intimidation tactic by himself that he is clearly using throughout all of his videos, that he's clearly trying to introduce to the courtroom today under the false pretense that he is a journalist.
The you say there's, I think, lots of videos out there. Have you seen any videos where it appears he's in the past received copies from the court and used those or edited those?
I haven't seen the court, any court videos at this time, no. He has recovered the sheriff's office body camera videos under public information requests, and those have been edited and spliced and
Objection, that's not factual.
used for his advantage.
Okay, but he's had the ability to get them and post them.
Yes, sir.
Okay, you say he's edited them somehow, Mr. Rebar. So to you, have you received court or other public recordings and been able to edit them and post them after the events as opposed to just your own live ones?
Yes.
Are you monetizing this stuff?
Just like MSNBC, just like CNN, just like ABC, when people view things, things are monetized. So just like all of the major media that's existed in this country for a couple of hundred years or across the world, if you want to get old school, has media always been monetized? Have people always paid for newspapers? That's just a historical thing. So I don't understand the argument that it's because it's monetized, it's not journalism. The Supreme Court, the courts have, how do you define journalism? Let's get into Article 1, Section 9 of the Nevada Constitution. That's freedom of press, freedom of speech. No law shall be passed to abridge speech or press. We all have freedom of speech in this country, freedom of speech in the state of Nevada under our Nevada Bill of Rights. We all have the ability to be members of a free press, whether it's you, Your Honor, whether it's Deputy Bueno, whether it's me. We all have the right to gather and disseminate information to other people in our communities or across the world as the technology will permit. Whether it was the printing press hundreds of years ago where the church was trying to suppress the printing press because they didn't want the information out there, to the modern day now.
And is your phone currently recording?
No, I'm looking at part of my argument here. Okay. I'm looking at NRS 4.360, which is denomination of court. Court always open where held. The courts held by justices of the peace are denominated justice courts. Justice courts have no terms and must always be open, period. Except as otherwise provided in this subsection. And 5, justice courts must be held in their respective townships. So justice courts are public venues.
There's no doubt about that. I don't need those sites.
And with, as we look at Fordyce versus Seattle out of the Ninth Circuit case, I don't know if you're familiar with that, or if we want to look at the state of Nevada and NRS 171-1233 and what our legislative intent was when the Nevada legislature codified that, and I believe it was the 2021 session where Governor Sisolak signed it into law. The intent of our legislature is to record and document and disseminate information about our government, specifically law enforcement, to the public. Fordyce versus Seattle, people in public were going out and recording a riot, if you don't know about that, back in the 1990s when that became law.
What is your benefit of your recording device as opposed to obtaining a copy of the court's?
I control my recording device. For example, I requested a record of my criminal trial where Deputy Bueno illegally arrested me and hotbox tortured me on a 95-degree day, closing the windows.
Hang on a second. That didn't go to trial, did it?
No, the case was dismissed.
Okay, hang on.
The case was dismissed, so I would reference, Thompson versus Clark out of the Supreme Court of the United States. I referenced that in the documents that I gave you. But basically, unless he gets a conviction, you've done a malicious prosecution is basically what the Supreme Court of the United States has said.
Okay, and I'm not here to litigate whether it was truly appropriate back at the prison or not. I'm here to look at, regardless of the truth of that, I guess there's an angle on lawfulness, but regardless of that, whether an protective order is needed.
Let me get back to your question, sir.
So the recording, that's what I'm getting at.
Right.
Like right now, like if you were recording, your camera is going to be in a fixed position. It's not going to be being moved around. The courts are automatically picking up mics and moving. So I guess why the additional extra and different?
I just got a copy of the court record for my criminal trial, and I ordered that. I paid the court some money. So number one, in this one, I don't have to pay the court money for a recording that I already own. But number two, on the recording that I paid for from the court, there was a recording of the video, but there was no audio. So I paid money to the court for a video recording, but no audio, so I can't use it. It
So there was
doesn't.
a glitch that prevented something. You
Right,
want, you
so-
want a backup.
So I want a backup, so I don't have any glitches, so I control the recording, and so I don't have to pay the court money for something that I can produce on my own. Without any interference, as I sit here, I can set up I brought a tripod, so if you need it to stand somewhere else, I brought a tripod that can sit on the table. I can put it wherever you want. It's an inanimate object that just sits there just like your cameras and documents the reality of what happened. And
What if for backup and safety's sake, I allowed audio instead of audio and video? What are your thoughts on that?
I would rather have both so we can watch people's reactions, facial expressions, body language.
But you won't see that. I'm not gonna interrupt the proceedings. There's not gonna be a moving of it to individuals.
Well, that's what I'm saying, Your Honors. If I can have a recording, I can put it where, and I can, on a video, I can see what those interactions are that it picks up in the amount of screen that you allow to be recorded. So I want the video so I can see those body, those facial, those reactions, along with the words that people are uttering. That way you can see both, and that way when I do disseminate the information to the public can have a more clear view of everything and they can make up their own decision. Deputy Bueno has accused me of altering things and editing things out that weren't. And I'm going to disagree with that, and what I'm going to do after I go home from now is I'm going to go repost his entire videos without the dead space taken out, where the law enforcement edited out their own stuff, and I'm going to post the entire videos again, and that way what he's represented here will be in the public. My only goal with doing this, I'm a business guy. I've been running a business in our community for decades. My family ran businesses. I got off my butt, got off from behind my desk, stopped running my business, risked my business to record government because I've been damaged by government officials. The only way that I know to fight back is to exercise constitutional rights to gather and disseminate information about the wrongdoing that I see in our state.
Hang on, I understand that. That's not an issue for
He's
today.
monologuing, though. I just want to point that out.
I got it.
So that's my goal. I've been accused of not being a journalist. So what is the definition of a journalist to the court? The definition of disseminating information, the Supreme Court's looked at that. As long as I'm disseminating information to the people, I'm a member in exercising my constitutional right under freedom of press, Article 1, Section 9, Nevada Constitution.
Okay, now regarding the timeliness of this, your written work says you knew of this at 10 o'clock yesterday. The deputy, or whoever the representative is, Kristen Marquez, indicates 4:32. When did you become aware of this, this hearing's potential?
About the time that, was it Marquez? About the time referenced by Marquez that you just mentioned there. If you do want to go look at my channel, I did post a audio recording of her telling me when this was, so I've got that firmly documented as to when that happened. So
Over the phone?
Yeah, she called me on the phone and I recorded the phone conversation. I was
Did
driving.
you ask her if you could record it?
It was stated in the very beginning of the phone call that this was a recorded conversation for Nevada law.
Mr. Rebar knew that he was attempting to be served.
Hang on. Okay, so I misread your request. I thought you were notified at 10 o'clock yesterday.
No.
Notified the hearing would be about 10 o'clock. Okay.
Yes, sir. Yes, Your Honor.
And
I believe he's posted videos of the contrary to that, Your Honor. He had business cards when they were attempting to serve him at his residence. He was avoiding service and tried to be served in Carson City. Washoe County couldn't cross the county line. He posted a video, another defamatory video before 4 o'clock yesterday. That's a matter of record as well. So again, he's distorting the facts in
okay,
order to try to
so hang on a second.
avoid this.
I've talked to you on these preliminary matters, and some of it is factual that I need to make decisions based upon it, and I neglected to swear each of you in. So would each of you please raise your right hands? Do each of you swear or affirm under the penalty of perjury that the testimony either that you have given, the answers you have, or statements you have made since the beginning of this hearing, and any information or testimony you provide from here on out either was the truth or will be the truth?
So help me God.
So help me God.
Okay. So, Mr. Rebar, did you know that law enforcement was trying to serve you with something prior to 4:32 or 4:23 yesterday?
Everything is posted online as far as my experiences of what happened.
That's not the answer.
I'm answering the question, sir.
So did you know they were trying to serve you with this or anything else?
Washoe County Sheriffs contacted me by phone after they left a business card taped to my gate.
When?
They left a business card taped to my gate, I think, was it Wednesday last week? I don't want to specify the exact date, I forget.
Did you ever call on to see what's up, or did they talk to you?
No, then Washoe County called me in the morning, it was about 7 o'clock in the morning, and I told them, they said, hey, we need to serve you. I said, okay, I'm going to be out and about. They said, well, where can we meet? And I said, well, I can be at my office in Carson City, and I believe there's a video online, so we can watch that to make sure that what I'm saying is accurate as I recall. I said, meet me at 9 o'clock. It was either 9 or 10 o'clock. And then they called me up later that afternoon, and that video's online too, that said that they couldn't come to Carson City to serve me. And I said, well, I can still come to Washoe sometime. And they said, no, we're going to give it back to the Carson City Sheriffs. And then the next day, Carson City Sheriffs came into my office in Carson. I wasn't there, and I told my office, I said, give them my cell phone number, have them call me, and I'll set up a time to meet them. I told them if they wanted to come serve me last night, that they could come serve me at my home in Washoe Valley. They said that they wouldn't do that, and I said, I will be at the courthouse this morning at 9:30 because I don't want to ignore the court, and if you're looking for me, I'm going to show up. I said, come serve me at 9:30 at the courthouse. I'll be here to check in and make sure I'm doing all the stuff right. And so far, I still haven't been served. I'm not trying to hide from service. I publish the videos that show me making the appointments, trying to be there, and then the government cancels the appointments because for some reason they can't come serve me wherever I'm at.
Do you have a copy of the complaint or the application yet?
Your bailiff gave me a copy of, so I just got this and I've had a few minutes to read through it, but I haven't had any time to thoroughly deal with it.
I believe
I can. Your recording that you're asking for is recording, not live streaming, is that correct?
I think I was live streaming one of,
What you want, you're saying you want cameras in the courtroom. Are you wanting live stream or are you wanting simply to record?
I'd like to do both if I can. But if I could live stream, that would be even better. That's more real. As Deputy Bueno is discussing, he's concerned about editing. If I'm live streaming, there is no editing, it's just live. And I do a lot of live streaming.
Your Honor, this goes beyond his editing. It goes all on his content and his false representations of everything that he posts. The video that he posted most recently yesterday that he's referring to was titled "Coward Deputy No Bueno Filed a Restraining Order," and then without any type of check or balance, has free license to commit libel.
When was that posted yesterday?
That was yesterday afternoon, I think just after 3 o'clock. So he was aware. He also filmed himself making contact with the servers that were trying to serve him. But the point that I'm trying to make about the videos and the camera.
Hang on. Describe that. Filmed himself with people trying to serve him.
Can you speak up one more time, sir?
So you're stating that he filmed himself when people were trying to serve him. What do you mean by that?
He filmed another monologue outlining his opinions on the service of him obtaining a business card from his residence and then went on to describe roughly what he just was trying to talk about as well.
How long ago was that up? Was it yesterday or?
It was yesterday afternoon before 4 o'clock. I was in a meeting with admin about that time. So, but again, sir, the point being is that Mr. Rebar has clearly gone beyond his First Amendment right when he has knowingly produced libelous slander and defamation against myself. He's done it in this courtroom today when he talks about torture and false arrest. He's been provided with investigations from the sheriff's office when he made a complaint of torture.
Okay,
All
those
video
those
evidence was
underlying,
presented to him.
hang on a sec, those ultimate underlying decisions, no, maybe they are, maybe they aren't, but there's not been a finding and an adjudication of them yet. And again, my issue right now is just recording, not recording. Looking at the statute in question, I have some fairly broad discretion, or the rules, I should say, have some fairly broad discretion in this area. The rule does hang on a second, using my phone for the rule. This is 230 subsection 2, a presumption that the courtroom proceedings are open to the public. That to be precise, there's a presumption that all courtroom proceedings that are open to the public, and this is, I'll note that no one's here. No one cares enough to come down apparently, despite their interest online, are subject to electronic coverage. So there's an underlying presumption that there should be, or it should be allowed, and then I have to make particularized findings under that subsection, whether to allow it in whole or in part, and then it goes through the factors that I've asked about. As far as the definition of reporter, it is extremely broad. It appears to be posting on all sorts of topics, according to what I've heard. This matter is a little different than many of the others. He's got what appears to be a very personal interest and axe to grind in this case, given his arrest, as opposed to things that might have happened in the other cases or situations just briefly described to this point. The timing of the request, according to the rule, needs to be 24 hours in advance. There's reason to believe that Mr. Rebar knew this was coming well in advance. He wasn't served with the exact nature of it. Washoe deputies not wanting to go into Carson deputies or process servers not wanting to go into Washoe, the schedules of both parties apparently conflicting. I'm not going to even speculate on the motives behind either party, but the 24-hour request in this case is basically, hey, I didn't get the exact service and the notice of what it was until 4/23, and then if I believe Deputy Bueno, there was already posts online knowing what they were. So we're looking at strictly, should this recording be allowed? The 24-hour requirement. hard to say under the two different versions here that there was an active avoidance of service. So there was short notice. I do have the authority to waive it or shorten time. The bigger questions in my mind are the factors I'm supposed to consider: the impact of the coverage, the privacy issues, the safety and well-being of individuals, the detraction from the dignity of the proceedings, and the type of coverage and the adequacy of the facilities. Here it appears to be a phone. Is that correct, Mr. Rebar, that the request is being made to use?
No, I've got multiple tools, but I've got a professional camera. Tripod and other tools to professionally record and document and disseminate information.
This one is a difficult decision in that the underlying allegations include the posting and alleged editing of material that has potentially caused issues for the applicant. In the application, references to others being riled up and reaching out to him, purportedly stoked by Mr. Rebar's postings is the argument. So the detraction from the dignity of the proceedings or the parties' ability to not be distracted in answering and process is in my mind when it's over and above the court ones. Again, the court ones record by video and audio. The feed automatically adjusts between the players to capture. There's been evidence that in the past audio recording has failed and video only has come through for whatever reason. That is always a potential. As this is at the heart of the matter and likely to be posted and likely very duplicative of the record the court makes that may fail from time to time, but is unlikely to fail. I don't think that I can say that Mr. Rebar is not a reporter. The timing gives me some concern. The distraction of the additional gives me quite a bit of concern. The delay, like I said, cuts both ways, but what I'm going to do is allow a supplement of the record if Mr. Rebar wishes to turn on the camera, have it at me, collect me and the voices of the parties. That can happen, and I'm finding under the subsection 2 of Rule 230 that is reasonable despite the late request and is the least distracting to the parties, especially given that this is the underlying one of the underlying allegations or issues in the case. So if you want to set that up and point it at me, feel free.
May I live stream, Your Honor?
No.
Okay.
I have a question, Your Honor.
Yes.
So if this order is granted and he uses those videos to further drum up more threats against me, then that would be understandably a violation of that order. and I could file on violation of that order by further posting those videos and incurring those threats.
Well, there may or may not be increase of harm to you. There may or may not be libelous content from either party's perspective. But I guess I'm not sure what you're asking. I mean, if what you're saying is if he posts the recording of me and the audio of the hearing, you want to do what with it?
Very shortly there'll be a cease and desist from my personal injury attorney to remove all content from YouTube, as it's libelous and damaging, and it was proven such. So in order for him to further where he's going with this now, my concern is obviously that this recording is going to be used in the exact same way that he's been stalking myself and my family.
And if there's some wrong that flows from that, there's consequences that are potential for it, but I'm allowing it. I am not ordering that he can or can't post this proceeding. That Mr. Rebar does at his own risk, like any person who posts anything under any circumstance. So he's allowed to record the court and audio of this proceeding, the other parties talking. That's been my ruling. We haven't, just for the, I'll call it the record, so to speak. The only record, according to statute, is the court's formal one. But for the sake of completeness, for Mr. Rebar, when we started, we have been talking since the beginning of this about his initial request, whether or not he could record the proceedings. I have examined Rule 229, 230, and the like regarding his ability to record. I have authorized a limited ability to record to protect the dignity of the proceedings and the individual's focus and ability to not be distracted, and the limitations that I have posted or ordered are that the camera, again, can be posted at me or directed at me, and it can record audio of anything else in the courtroom. That's the extent of my ruling. I'm not, again, ruling whether or not he can do anything with the recording. So the next issue to address before getting to the merits of the matter are there was an opposition to the hearing. My understanding after reading it is that Mr. Rebar is asking for a continuance of this hearing because he was served, well, he was notified last night and indicated to the representative trying to serve him that he would be here. He was notified, according to the document, about 4:23 in the afternoon, stating he would be here. He has shown up to court, but he did not have the documents in hand until he was here. He indicated that he had the opportunity to briefly read the application. So the allegations that Mr. Bueno is making in attempts to obtain a protective order. So Mr. Rebar, you are here. You have submitted yourself to the jurisdiction of the court by showing up. You've been given a copy of the document. You have, you said, briefly read it. What do you need additional time for?
I'd like to go over the documents point by point. I'd like to go and I've got a subscription to LexisNexis. I'd like to go look at a lot of the case law. I'd like to confer with my attorney, Rich Salvatore, and get his personal advice and legal advice on dealing with this. And I'd like to take the time to write a complete response to the complaint and counter those issues and present evidence within my response.
This is in large part stemming from an event at the prison how long ago?
August 30th, 2022.
And then since then, you've been engaged in court hearings and making videos about this underlying subject matter, is that right?
For a time period after my arrest, I stopped making videos. My First Amendments were suppressed out of the fear that I was dealing with.
Did anyone order that, or did you do that?
That was just personal fear. Just personal fear of the retribution that the government was bringing down on me.
So hang on a sec, when you read the document, were you surprised by any of the contents?
Yeah, I've never made a threat against the deputy. Didn't even know he had children until I read this document. Don't know anything about him or his personal life. The only thing that I'm concerned with is under his office, under his authority of law, doing his job. And from what I saw, he's violated my constitutional rights. And as you see that I've noticed the court, I have filed a tort claim against him and against many other individuals involved in the arrest.
Just 2 days ago.
Whatever the day, I gave you a copy of the complaint attached as Exhibit 1.
January 29th. So.
Yeah, and I've been working on that for a couple of months, so I did file that the other day. That's over at the process server to get served, so Deputy Bueno should be served with that very shortly, along with all the other parties named. So I do want to move forward, and he's made some allegations today, and I want to answer those allegations, and I hope he wants to answer my allegations. There is no personal animus in any of this.
So hang on a second. You say you want to move forward. You want to defend yourself at a future date against this application for a TPO. That's what you mean by moving forward, or do you want to do it now?
No, I want to take my time and give you a written response to his complaint. And I want to counter all of his arguments, and I want to bring my documentation. As noted, I record and document and disseminate the information. There's videos showing exactly what I've done, exactly the actions, and we can compare those. So that way there doesn't need to be a question as to what I have or have not done. It's out there, it's recorded, just as his actions are. And I want to bring that information into the court in a reasonable way that's concise. And right now, if I've got to do it, I've just got to go blah, because I'm not prepared for this at all, because I found out 10 o'clock this morning when the gal from Carson City Sheriff's called me. Did I have knowledge that they were trying to serve me? Yes, I was on the phone trying to make arrangements to be served, to be at the locations where I said I would be, and then they kept changing the schedule on me. That's
not this morning. You were here this morning.
Oh, absolutely. I'm one of those human beings. Early is on time is late. I don't like being late. I like to be early. I like to be on time. I like to deal with the problems that are in front of me and solve the problems. This is a problem to solve.
If I were to consider this request essentially to continue this hearing, how much time are you asking for?
What's the normal time of service in one of these things? When was this originally filed, and how long has it taken to? So it's taken them. So this was filed on January 19th. Today is the 31st. So it's taken them, 12 days to call me up on the phone and say, hey, serve me. They could have called me 12 days ago when they first did this, as opposed to calling me here at the beginning of this a few days ago.
So if I were to consider setting it over to another day, how much time do you need? A week?
Probably 10 days. That's probably fair. It gives me a week and a weekend to look at things.
Mr. Bueno, did you receive, I believe my bailiff told me you received a copy of the opposition to the hearing. In large part, there's it's not a long document, but there's some contesting of the underlying actions back at the prison a few years ago. But the whole gist of this entire document is asking for a continuance. We've heard now it's fairly brief of a continuance. What are your thoughts on that?
The damage has been done, and it's taken this amount of time to at least have a hearing on the matter. My thoughts are the threats to myself and my family instigated by Mr. Rebar are going to continue.
Objection.
And I believe that's his intention at this point, to continue to post inflammatory conduct in violation of NRS 200-575. And so I did briefly be able to review his opposition. I did note his continuance in writing of those false allegations as well.
But what are your thoughts on going now versus just plain language with me? And maybe I didn't ask a good question, but what are your thoughts on doing it now versus next Friday, some point after that?
The
Or I'm sorry, next Wednesday. We normally hear these absent a special set on Wednesdays. So if it were to go on a normal schedule, what are your thoughts on a future hearing as opposed to doing it now?
I would like a hearing as soon as possible. Obviously, there's exigency with ongoing threats to my family.
Okay.
So as soon as possible.
And I read in your original application, and this just goes to whether or not I continue this, an allegation of threats, and that is a word, like many others, that's subject to interpretation. For example, I have a case where the definition of tumultuous is at issue, and tumultuous, when you read it in a dictionary, is violent, riotous, loud types of activity. But in normal communication, you could say that, the Buffalo Bills, for example, had a tumultuous season, ups and downs and losses and injuries and the like. So when I hear the word threats, the context for a protective order, what I'm looking at is like either an explicit or an implied threat of actual physical harm to you, your family, your property. That's the type that I'm concerned about when I'm looking to continue or not. Has there been, on the recordings you've watched or communications you've had, that type of threat from Mr. Rebar himself?
Yes, sir.
Describe one.
His comments are a matter of record. The commentary from his false statements that he's made. I've received phone calls advising that they know where I live. They know where my children go to school. I've had family contacted with the same type of comments, all fueled from his false accusations.
Other people have reached out, not Mr. Rebar, is what you're saying?
I stopped answering the unknown callers but I'm still getting them through my voice messages through work. I'm not listening to all of them at this point because they're extremely vile.
What about a specific threat from Mr. Rebar right now? I'm gonna come to your house and follow you in your vehicle everywhere you go to annoy you, or I'm going to hit you, or I'm going to do something to your property. Anything explicit like that?
I would have to go through the hundreds and hundreds of comments in order to specifically see. I don't watch all the content of his videos. I have someone that's doing that. So I would have to defer, and maybe that would be a time to be able to adequately present those as well.
Okay. So on the continuance question, it sounds like both parties could use time to prepare their essentially presentations, marshal their evidence. Normally in these hearings, they are fairly quick and summary. I hear verbal descriptions, make a decision. But it sounds like while I could likely do that, this one is like all cases, it's important to both parties. So I'm inclined, I guess, to continue it, but the question is to when. Before we started, when I saw this opposition to the hearing. I'll call it opposition today. I'll call it a motion to continue. Check with the clerk, had her check into the future, and we'd only, because of we were in the middle of hearings when I received this request. I looked as far out as the following week. Next Wednesday, there's only one case, a small claims at 1 o'clock, and there's the ability to come in later, say 2 o'clock, and there'd be about 3 hours that I could obligate the court to. It wouldn't be me, I'm already assigned elsewhere, but next Thursday, 2 o'clock, we could set this. It's not quite as much time as Mr. Rebar is asking for, but I think it also strikes a balance on the potential concerns that Mr. Bueno is bringing forward, his underlying concern for and allegations for safety. So, is it correct, Ms. Clerk, that 2 o'clock next week is free if there's a small claims at 1 and that's it? Okay. That's Wednesday the 7th. Okay. That date isn't set in stone. Those are my thoughts on it. Mr. Rebar, is that possible for you?
Thursday, 2 p.m., sir? Your Honor?
Wednesday, 2 p.m.?
Wednesday, 2 p.m.
Next Wednesday?
I will make that happen. That gives me more time than I've had since last night to look at the papers and respond.
And is that
Yes, sir.
acceptable to you? Okay. Like I said, it will not be me. I have the prior trial set in a different jurisdiction. There'll be another judge sitting here, 2 o'clock next Wednesday the 7th, to discuss the merits. Mr. Rebar, you would likely want to, I'm not going to, I don't know what information may change between now and then, so I'm not going to have this be a continuing order for cameras in the courtroom. I've allowed it in the limited manner today after our arguments. So if you wish to do it again, put in a request, and either the normal judges or the judge who will be presiding that day can have advance notice to look at it. So my order was for today. So if you wish to do a recording next time, another request, okay?
Yes, sir.
Current address, I can mail them the notice.
A notice.
For next week's court.
My address should be on my responsive motions.
Okay, I'll mail
It should be on the top, I think.
Okay, perfect, thank you.
Okay, and then, Mr. Bueno, do you need any additional notice of next Wednesday at 2 o'clock?
I'm sorry?
Do you need any additional notice? She was gonna mail a notice to, Mr. Rebar. You have it? Okay. All right, we'll mail out notices, and you're both on notice, and Mr. Rebar, you are, for legal purposes, considered to have been served with the document. You've received it, you've acknowledged it, and you've made an appearance in court. So service is complete. I think that's it for today.
Thank you, Your Honor.
Okay, thank you.
As I recall, you're the same way. You went down things very precisely. I appreciate that. Thank you, sir.
You're welcome. Have a good day.
Thank you.
So that was our first hearing together with Deputy Bueno. Anyways, let me know what you guys think. I appreciate you watching it. And just as a what's to come, I'm going to file what's called a special motion under NRS 41, and it goes from 41-635 up to 41-670 under the Nevada Revised Statutes, and it's called a SLAP, S-L-A-P-P, and basically it gives somebody like me, when you're out there exercising a constitutional right, an opportunity to slap back at what is basically a frivolous lawsuit. And I believe that what Deputy Bueno has done is filed a frivolous lawsuit against me. I haven't done anything that meets the definition of the crimes that he's accusing me of. And if you listen to that video, he's obviously trying to intimidate me with future crimes coming against me, misdemeanors and felonies for posting these videos. That was his threat in the courtroom. So that doesn't make me feel very good, especially with what I see at the Carson City District Attorney's Office and the Sheriff's Office, where there's signs trying to keep the cameras out when they should be open to the cameras. Anyways, I'll let you guys all know what happens this next Wednesday at 2 p.m. I'll try to live stream as much of that as I can, and if I can't live stream it, then I'll post it a little later like I'm doing with this stuff here. So, talk to you later.